Hi, it's Cindy Kiner from the HR Connection again. And over the past few days, I have been producing videos and addressing some frequently asked questions that employers have about COVID-19 and HR issues surrounding this and the legislation that employers need to comply with. So today I'm going to address a few more of those questions that people have asked. The first question is, if I reduce the hours my employees work each week, can they collect unemployment? The answer to this is maybe, probably. Anyone can file for unemployment, and whether or not they can collect depends upon the amount that they actually make. The calculation is determined by the state, and you can actually find that in Indiana. You can find it on Department of Workforce Development's website. You can find the calculation. Any wages that they make are offset dollar for dollar from their total benefit amount. So, for example, in Indiana, the maximum that anyone can make is $390. So, if you pay them wages for part-time work during that time and they make $200, then they will be able to draw $190 for that particular week. The next week, if the wages are different, that amount will be offset as well. So it's a week-by-week basis. Second question that's actually related to that is, if my employees are paid unemployment for a particular week or for a partial week, will they still receive the additional $600 per week? So under the CARES Act, there was an additional $600 added to the unemployment benefit. And yes, if your employees are eligible to receive any money at all during any week from unemployment during a particular week, then they will receive the additional $600 for that week. So let's say their maximum is $390 and they make $350, so they only have $40 coming. They will still get the $600 plus that $40. So there is some more information that I can give you, though, about that additional $600 you need to keep in mind. This was effective March 29th, so anything that was filed prior to that will not be subject to the $600 extra. Also, it goes through July 31st, so anything after that will not receive an additional $600. The target date in Indiana for people to start receiving that $600 is April 20th. It may or may not happen then. That is the target date. But when it does happen, it will be retroactive back to March 29th. All right, question number 3. I have applied for a loan through the Paycheck Protection Program. I understand that I need to continue paying my employees in order for the loan to be forgiven. Can I have my employees work on something different than what their job description says? Okay, so the Paycheck Protection Program is also under the CARES Act. And it is a loan that employers can apply for, and as long as they continue paying their employees, they continue with their current staffing levels and continue paying their employees at least 75% of what they are making, then the loan can be forgiven. It doesn't mean that if you go below the 75% that none of it will be forgiven. It just means it will be reduced. The forgiven amount will be reduced. So, but to answer the question about whether they can do other work, the answer is absolutely, unless there is a collective bargaining agreement that says otherwise. Also, if you have any youth workers that are under 18, you still need to keep the normal restrictions in mind. But if your business isn't conducting its normal operations, then and you want to keep your employees there, you want to keep them active and engaged and have them doing something so that you continue paying them, then yes, as long as they can maintain safe social distancing and everything is safe for them, then you can assign them other tasks other than what is on their job description. I do have one final note for you to keep in mind. Yesterday, during the White House press briefing, the U.S. Labor Secretary mentioned that there have been numerous workers who have contacted OSHA because they have health concerns about their workplaces. And many of them actually feel like they've been illegally disciplined because they have expressed those concerns. He was very clear that OSHA will investigate those claims, that OSHA will enforce all regulations, and that they will not tolerate retaliation against any employees who feel like they have been discriminated against because of their concerns about COVID-19. So that said, the best thing that you can do is to make sure that your workplace is safe and take every precaution that you need to take that's necessary. Address concerns as they come to you. If someone expresses a concern, don't sweep it under the rug and don't dismiss it. This is a time to be flexible. It's a time to be considerate. So even if you personally are not fearful of the virus, or you feel like it's not a big deal, whatever your opinion of it is, many of your employees are. You may not know what they're living with at home. Maybe they have a high-risk individual living in their home, and so they're concerned about that. So this is a time to be compassionate. We're all dealing with this in different ways, and one thing to realize is that your employees are going to remember you after this is all over. They're going to remember how you dealt with this and how you dealt with them concerning this. So thanks for watching. That's it for today. If you have more questions, please post them below or email them to me. Remember to subscribe to our YouTube channel and follow us on Facebook, Instagram, and Twitter. And we will see you on the next video. Thanks.